Thank you all. Please be seated. This is a time set for oral argument in our case number CV230273 and 0689, Freddie Brown and others against the City of Phoenix. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to use a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel and to avoid any avoidable embarrassment, let me ask everyone who is here to make sure that your cell phones are turned off so our proceedings aren't being interrupted. We've read the briefs. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument today. Our proceedings are being recorded and will be posted to YouTube and maybe live streamed as well. I'm not quite sure, but that suggests to me that we would very much appreciate you telling us your name and the party that you represent as you begin your argument. One other thing before we begin with counsel for appellant. The parties and counsel undoubtedly are aware that the court is, by some definition, about 100 feet from the boundary of the zone. The court has, and its staff has driven by the zone many, many times over the course of our day-to-day lives. All of us have been on the court since at least 2019. We have not perambulated or gone to visit anything in the course of considering our appeal, but it is a little bit different than the more typical case where the appellate court would be completely ignorant of the, appropriately ignorant, other than in the record, of the grounds and the facts and the specific location. I'm guessing that's not a surprise to anyone, but I want to make sure, to the extent we can make a record of things in this court, that we make that plain to you this morning. So with that, Ms. Stewin, and you'll have to help me pronounce your last name if I've mispronounced your last name. You may proceed.
May it please the court. My name is Trish Stewhan, pretty close, and I am joined with my co-counsel, Justin Pierce, and we're here on behalf of the City of Phoenix. We'd like to reserve 5 minutes for rebuttal. In October of 2020, the City of Phoenix experienced a dramatic increase in homelessness and adopted strategies to address those. By 2022, the city had constructed 600 shelter beds, and by 2023, 482 beds additionally came on board. Those 1,000 beds were crucial so that during the pendency of this case, the city could go to the area surrounding the Human Services campus downtown, which this court has driven by, and be able to offer beds to involuntarily homeless people that were occupying public property around that campus. The city spent over $19 million in providing the shelter and closing the blocks around the campus to camping. Despite these actions, the lower court entered a permanent injunction, and that permanent injunction requires the city to maintain the area free of tents, biohazards, and individuals committing offenses against public order. The City of Phoenix asked this court to overturn the permanent injunction for 3 reasons. First, the legal theory underlying the cause of action, that this is just a nuisance case, is fundamentally flawed. Second, even if the legal theory was sound, the court should exercise caution here, relying on separation of powers and the political question doctrine, especially when considering long-term monitoring, stopping individuals committing offenses against public order. And finally, third, the permanent injunction is impermissibly vague. Ultimately, this case is a troubling one. Homelessness is a vexing public policy issue, especially after a pandemic, affordable housing crisis, and inflation. But separation of powers requires that we keep in mind the distinction between judicial, legislative, and executive branches, and we worry that this order threatens to commandeer city resources into perpetuity. Yes, Your Honor.
I'm going to ask you to address those backwards.
Okay.
Can you start with number 3, and we'll go on from there.
Okay, so starting first with the scope of the permanent injunction. If you look at Arizona Rule of Civil Procedure 65, It's clear that the rule requires that the court state in reasonable detail the acts that are either restrained or the acts that are required. Here, it's important to look at the tents and biohazards. Even if that feels fairly narrow in scope, you have to make sure there are no tents, makeshift structures that are reconstructed in the area surrounding the Human Services campus. Let's start with that last one, individual committing offenses against public order. That last prong is very troubling for the city of Phoenix and its law enforcement. As we can see, we'll talk in separation of powers about cases like sensing, but I think it's important to consider that type of a case in this prong as well, to consider what law enforcement resources are committed to downtown or any area throughout the city, and that will obviously vary over time based on funding, budget, the number of police officers, if there are shortages, scarce resources that have to be prioritized. But this order requires the city to stop individuals, stop crime.
Let me ask you a couple of sort of defining questions
Yeah.
that may be more at 50,000 feet than where you are right now. With respect to the terms and specificity of the permanent injunction, it requires the city to take certain actions with respect to public property, but that's the city's public property, right?
Yes, Your Honor. The city, and there's different types of public property.
Right.
So the city of Phoenix obviously owns just, flat out property, places it can build buildings on. But for a city or a town like Phoenix and throughout the state of Arizona, municipalities own vast amounts of public right-of-way, right? The easements, the 6 feet beyond the street. And it is particularly in those easement areas lining every block of the city of Phoenix where if there is a homelessness crisis under Ninth Circuit law, 14th Amendment and 8th Amendment considerations, the city has some limitations on the ability to keep its public property, those easements, free of encampments.
But that clarification is helpful because the injunction itself talks about public property, but it's the city's public property. You mentioned Ninth Circuit case law. That's instructive but not binding on this court. You agree?
Yes, Your Honor.
Do you dispute, does the city dispute the finding of a public nuisance here? I did not read your briefs that way.
Your Honor, the city does not dispute that the physical conditions surrounding the Human Services campus would constitute a nuisance in terms of trash, debris, or other physical hazards. However, for liability to attach, the city believes that you must show under the restatement and the Armory Park cases that either you set in motion first that nuisance or you fail to take reasonable steps to address them.
And that's how I read your briefs as well, that
Yes.
there was no dispute that there was a public nuisance here. It's the question of whether the city could be responsible for what is a mandatory injunction, affirmative action. It's not a prohibitory injunction, which, requiring affirmative actions and injunctive relief is sort of the hardest showing you can make. I think case law for many years supports that.
Yes, Your Honor, I agree.
And then is there, what I looked for and would be interested in your thoughts on the specific boundaries of the zone. I've seen reference to a couple of sort of general phrases, including bounded on the south by railroad tracks and other things like that. But what is your understanding of the boundaries of the zone?
Your Honor, if you look at, I guess, in terms of the, I think we've referred to the area around the Human Services campus. There are, the railroad tracks. There are different areas throughout the briefing. But specifically in the city's efforts to come into compliance, the city closed multiple blocks, and there was 11 enhanced engagements going block by block. So I can certainly come back up in a rebuttal and put up a little bit more of the street signs that we believed were closed as a part of it and address that. But there were several blocks that the city went above and beyond, trying to say, okay, if this is the area people are concentrated, this is the area we need to build shelter and help people relocate.
And I understand I'll call them remedial, but how about compliance efforts? I think that's
Yes, Your
really
Honor.
be it the preliminary or the permanent injunction. And we have a map of some of those efforts.
Correct.
But I guess what I was looking at, it sounds like the city is comfortable with the definition of the outer boundaries of the zone where those boundaries are.
Yes, the city hasn't disputed the areas. There was some flexibility over time of where people were camping. I mean, homelessness is not static. The numbers increase, they decrease. As blocks were closed to camping downtown, some people moved another block away. And so the city increased law enforcement response and increased shelter so that they could offer anyone who requested it another place to go so that they could close all the blocks. But there has been some fluidity, I think, throughout the case, but the city is not objecting necessarily to the scope of what is or was the zone downtown.
Thank you.
Going back to causation just a little bit.
Yeah.
So tell me your thoughts about the court's ruling. The court said the city caused, I believe, and maintained. In your briefing, I feel like the city focuses quite a bit on causation, but very little on maintaining. Tell me your thoughts on that, because I view those two words as having different legal significance.
Thank you, Your Honor. I would agree that they do have different legal significance, and I would assert that the city did not maintain any area around the Human Services campus as a homeless encampment. The record was clear. The city conducted tri-weekly cleanings. The city made sure, starting in about December, that it did more enhanced engagements where it was looking to actually sanitize the streets, connect people with services, and tell them to leave, and then eventually closed the areas. But to maintain, I think, is to say you are directed here. And there was some comments in the briefs about tents,
I
but
disagree.
none.
We're talking about causation. You directed people here. You caused this to happen. Maintaining means you did nothing to mitigate it. You allowed it to continue. So can you address that a little bit?
Your Honor, I think I agree with you that maintaining would be you did nothing to mitigate it, but I don't think that are the facts at hand in this case.
If we pause for a moment, when we look at the temporary injunction, prior to the issuance of that, what was the city doing in the zone?
So in October of 2020, the city first put together the strategies, and they included multiple things: creating an Office of Homeless Solutions to hire people, to offer services, to build shelters. So while this lawsuit was being filed, the city already had hundreds of beds coming up on board, so that in compliance with Ninth Circuit constitutional concerns with involuntarily homeless, the city could offer people a place to go and then enforce its sit, lie, sleep bans.
So that was in 2022?
By the end of 2022, the city had 600 beds on board. It wasn't enough.
The zone was created or became larger, an issue in 2019, 2020? Do we have any?
Yes, the record below, if you look at the preliminary injunction opening brief, you will see attached to that testimony from Deputy City Manager Gina Montez, and you will also see some Maricopa Association of Government point-in-time counts. And those point-in-time counts show that homelessness dramatically increased in the city of Phoenix in 2020, and that continued in 2021 and 2022. So in 2020, there were
2020 and 2022, what actions did the city take to abate the public nuisance that you agree is a nuisance?
The record shows that the city of Phoenix was offering tri-weekly cleanings to sweep. They were putting out sanitation stations, and they were building shelter so that they could legally use their camping bans. And so I think those camping bans are important because the city has been walking something of a legal tightrope. On the federal level, we have camping sit, lie, sleep bans in Phoenix City Code, but those are constrained from law enforcement being able to use if an involuntarily homeless person doesn't have another place to go, a shelter bed, or through the amended grants past decision, we now see potentially another public property, an outdoor area, or a campground, which the trial court focused on in this case. So the city also, you would see in the record below, showed that there were arrests and citations made, trespass laws. There were violations for public urination. Plaintiff Brown testified that when he called police to trespass someone, they trespassed him. So there was no wholesale failure to enforce laws. There was a limitation on the ability to enforce two laws: 2330, which is camping, and 2348.01, the sit, lie, sleep. And in order to enforce those, which we are seeing now the city has returned to enforcing them, that was reliant on shelter. And so it took about 2 years to come up with over 1,000 shelter beds. And the city is committed to 800 more. But those types of actions show why this is really a governmental decision, a legislative policymaking decision of how to address a societal crisis like homelessness. And that, Your Honor, takes time.
Counsel, you're just a couple more kind of definitional questions for you, so bear with me.
Yes.
There's no argument by the city that the injunction is moot at this point.
The preliminary injunction?
Well, we're largely wouldn't you agree, dealing with the permanent injunction?
Yes, Your
'Cause it's
Honor.
kind of folded into that.
I mean, I think the preliminary injunction is a concern that, I mean, it's something that could happen again, but realistically, I think largely it's been mooted out by the permanent injunction, and the city's main concern is maintaining this injunction into perpetuity.
But the permanent injunction, you're not arguing that's mooted by your
No.
compliance. And although called permanent, that doesn't mean it will last forever, correct?
There's no end date in the order, Your Honor.
There is no date in the order, but is Rule 60 an option if the city believes at some point that it is no longer necessary?
I do think that the city could at some point move to set that aside or take some other actions.
That's not happened to date,
That
to
is
be
not.
sure.
No.
And has there been any effort by any of the plaintiffs claiming that the city hasn't properly complied with either the preliminary or the permanent injunction, like a show cause hearing or something like that?
There's been nothing formally filed in the Superior Court.
I appreciate that, and I appreciate the carefulness that you have provided. That's how I read the record as well, and if there are other things outside of the record, that's a somewhat different issue. I interrupted
Your
you.
Honor.
Please continue.
No, Your Honor. I think, taking the last minute here before kind of getting into potential questions you may have or rebuttal time, I think it's important to look at the Sensing case. Sensing was concerned that courts would run the serious risk of constant or recurring supervision over daily activities of the police. Separation of powers is firmly rooted in Arizona in Article 3 of the Arizona Constitution, and in the Puentes open meeting law case, the courts exercised concern with getting into areas that are constitutionally reserved to another branch of government, building structured campgrounds, right? The amount of resources that would require in taxpayer dollars, or there's a lack of judicially managed standards. How do you determine if the city's doing enough, acting reasonably enough to stop people from committing crime?
I can certainly understand your
Yes, Your
reliance
Honor.
on sensing, because it seems compelling in some ways, but it's the key point to me, it's not a public nuisance case.
Your Honor,
I mean-
I agree. That's they're dealing with a solicitation ordinance, a panhandling type ordinance. But in that case, the court similarly was concerned that the end result is to effectively order law enforcement to make an arrest or prosecutors to prosecute. I think the same principles apply whether it's panhandling or nuisance. There is a certain level of law enforcement discretion, and that may be resources. It may be Ninth Circuit case law. They're trying to figure out how to constitutionally take action. And I think in this case, we'd recommend that the court exercise some restraint in light of sensing and separation of powers.
And I understand your point, but to Judge Brown's question, sensing was a mandamus asking the city direct its law enforcement officers to enforce a city code provision, the
Correct.
anti-solicitation. It wasn't abating a nuisance.
You're correct, Your Honor. However, this case is also mandamus. Plaintiffs packaged together mandamus, declaratory and injunctive relief around a nuisance theory, but ultimately, mandamus requires, you can have mandamus to compel a non-discretionary ministerial action. Abate a nuisance may feel like go clean it up, but in the context of a city or town in rural Arizona, in the city of Phoenix, that can become an ability to house 1,000 people.
And I understand your point, but there are decades of case law from our Supreme Court holding cities responsible for public nuisances that they've either created or maintained on their land. Would you agree?
I do agree, Your Honor. And I think, setting aside my last couple of minutes.
And we'll, with the indulgence of my panel, we'll give you a couple more minutes, and we'll give Appley a couple more minutes as
Thank
well.
you, Your
So-
Honor. But to answer that, I want to be clear. The city is not saying that as a municipality it can never be held liable for nuisance. Of course it can. The city is simply saying when you look at those physical conditions, and they are hard to look at, you drove past them, they are shocking, to realize, though, that there are difficulties in cleaning that up on a public property where individuals may have constitutional rights and there may be limited resources and it takes time. So we would exercise and ask this court to exercise some judicial restraint and recognize separation of powers concerns with the order.
Thank you, Counsel.
Thank you, Your Honor.
What I'm going to do, unless my panel members object, is give appellant another 2 minutes, so 5:04 for rebuttal, and I'll give appellee 2 more minutes as well, so we have 22. Whether you choose to use those extra minutes is up to you. But Mr. Worman, when you're ready, you may proceed.
Good morning, Your Honors, and may it please the Court, Elon Werman on behalf of the plaintiffs, the appellees in this case. I'd like to do 3 things with my time permitting, of course, and recognizing that I'm highly likely to be derailed with my plan. First, I'd like to address the proper framing of this case. This case is not about the city's discretion to use law enforcement, to address homelessness, to make hiring personnel decisions. The city has discretion to do any of those things and many other things too. But it can never exercise any of the discretion that it has to violate the First Amendment, violate equal protection, or violate state law, including the law of public nuisance. Second, I'd like to address causation, which is it's related, because I do not agree with what was stated about the restatement rule, which allows for landowner liability not only if there's a failure to take reasonable steps to abate, but if the landowner consents to the nuisance. And here the record shows evidence of consent. And then the third thing, time permitting, I'd like to talk a bit about the judicial role, including, of course, the scope of the injunction. But we are not asking this court to play policy czar. We did not ask the lower court to play policy czar. We are asking the courts to apply established law, including state law enacted by the people's representatives and city code that Ms. Stuhan referenced, enacted by the people's representatives in the city level. We, the people, have made the policy already. We are just asking for the courts to apply that policy and to enjoin the city from ignoring those policies.
Counsel, let
Please.
me ask you just a couple definitional questions. You heard me ask appellant's counsel as well. Although the permanent injunction, and that's our primary focus today, I believe recognizing the preliminary injunction is kind of mooted into or superseded by the permanent injunction. When it makes reference to public property, that's the city of Phoenix's public property. Do you agree?
Yes.
And are you comfortable with, you heard your opponent, that the city appears to be comfortable with the definition of the zone?
Yes.
Are you comfortable with that as well?
Yes, Your Honor.
Delineation? And then one other question I'd like for you to address at some point. The permanent injunction dealt with what should happen with a public nuisance, either created or maintained or allowed. I don't want to, for purposes of my question, to stumble on that term, and they're important, by a municipality on the municipality's property. But it didn't say something like simply abate the nuisance. It became more granular, including maintain its public property in a condition free of individuals committing offenses against the public order. Tell me about how compliance works with something that broad, given that the city, I think fairly, can't be held directly responsible for strangers to the city, not its employees, but strangers who commit offenses against the public order.
Yes, Your Honor, let me say a few things about that. The first thing I'd like to say is that we are entitled either to mandamus or injunctive relief, or quite frankly both, and that is not we don't interpret that part of the order as being part of mandamus. It could be part of injunctive relief. We cite a number of cases for the proposition, including where courts have held through an injunction the specific steps that needed to be taken for an abatement, and we did not see any response to those cases. So courts are allowed to fashion relief, including through injunctive relief, and we think that's what it did here with that third component of it.
Would that allow your clients, though, if somebody publicly urinates in the zone, to bring show cause contempt request against the city?
It would not, Your Honor, because the judge accounted for that. The judge specifically said the court does not intend this order to create a private cause of action for every non-pervasive violation of subsection B and or C. So the court already accounted for that. The way we interpret the order, which we think is the only fair way to interpret the order, is that the city shall no longer have a policy of allowing a zone, an area in town where it is going to operate an open air, no barrier shelter where there are commonly occurring crimes against the public order. That's how we interpret it.
And a policy that's effectuated, right? I mean, if they have a policy they don't put in place, we probably
Correct.
don't, as a judicial system, care much about that.
Correct.
as a elector, you might, but
Correct.
but we probably don't. And one sort of follow-up question, then I'll try to be quiet.
It's no problem.
Have there been, I'll try, have there been any enforcement actions taken for either the preliminary injunction or the permanent injunction with the court?
There has been nothing formal, and I'll let Ms. Stuhan correct me if this does not track her recollection, but the plaintiffs in the case did send on 2 occasions a few photos of the situation seeming to get a bit out of control near the Human Services campus, and we sent it to the city's attorneys, and they immediately said, we'll take a look at this, thank you for letting us know, and we've had no issues in the months since the injunction was implemented.
And I appreciate that clarification. Just so I'm clear, there's nothing in the record of any formal request to, for show cause or otherwise, for either the preliminary or the permanent injunction.
Correct, and in fact, the parties agreed to vacate the return hearing because we agreed that the city had adequately complied with the court order.
Thank you.
And so, but this question about the persons committing offenses against the public order does go to the last issue that Ms. Stuhan talked about, this question of enforcement discretion. And so let me just return to that a bit, because the city here is not being sued as the owner of a police department. The city here is being sued as the owner of land. They are operating, as I just said, in open air, no barrier shelter on the city streets in downtown Phoenix, or I should say they did before the injunction. It is no different. It is no different than had they built a leaky sewage plant or an asphalt plant or a brick and mortar homeless shelter in that area and failed to take into account the secondary effects. It is simply irrelevant under nuisance law whether it's brick and mortar. Nuisance law is concerned with activities. So to give an example, which is, by the way, in the restatement, if a private landowner invites a bunch of high school kids onto his lands to play golf or baseball, causing a nuisance because the balls break things, it's irrelevant if he built a mini golf course on his land. It's irrelevant if he actually built a baseball field on his land. The point is, it's the activity that is being allowed on his land. And for that reason, too, it is irrelevant that third parties are involved. This shades into causation, which I'll get into a moment, but we cite 100 years of cases for multiple jurisdiction for the proposition that public encroachments on the public streets, the public nuisances on the public rights of way, are remediable by a writ of mandamus, that the city has a duty to remove those. And every single case involved a third party creating the nuisance. If the city's theory is correct, Your Honor, then all those cases would have just been, oh, well, it's enforcement discretion. They can't get them all. But of course not.
But counsel, isn't this at least a bit unique in that most of those cases you're talking about sewer leak, I assume, and there's cases involving debris or concrete where somebody has encroached on a public right of way. That's removing, I think the city put it, removing concrete. You're also talking about removing people. Physically taking them, removing them from the tent in order to remove the tent. Are you not? Doesn't that invoke some special consideration here or some trepidation for me as a judge, like where we're going with this?
I don't think it does at all. For two reasons, Your Honor. The first is, how do these cities abate these nuisances created by these third parties in all of these other cases? It's not like the city comes in and physically removes the curb pumps or whatever it is, though sometimes I'm sure they did it. They would file prosecutions against the owner of the hotel or the owner of the gas station for encroaching on the public rights of way, and suppose they ignored them. What happens, right? So all of this eventually involves people. Right, and you can't get away from that, Your Honor. And so I just don't see how it's different. And let me add that the order doesn't require them to use police at all, and they didn't use police to clean up. If you look at their briefing, when they cleaned up the zone, what did they send out there? All of their outreach people. And it turned out that 80% now, in given a court order that says you can't stay here anymore, but here are hotels, here are shelters, here are other places you can go. It turns out when not given a choice to be there, 80% accepted. They didn't need police for anything. And so, again, this is just from their brief. They didn't mention that they had to use a bunch of arrests or police resources. And so I would just keep that in mind. This is in principle no different than requiring a private landowner to keep high school kids off of his land. It's no different. I'm sorry, Your Honor. I know you were about to have a question.
So let me follow up a couple of questions. One that you heard me ask Appellant, you're not arguing this is moot. The permanent injunction, correct?
Correct.
And then the other, you mentioned in response to Judge Brown's question, case law for a century from other jurisdictions. much of that, perhaps all, is common law. The restatement, of course, is common law. This at least has aspects of a statutory public nuisance, although we have looked to common law cases. How do we kind of bridge that gap when it comes to causation, which isn't as robust in the statutory definitions of public nuisance, but we're asked to kind of figure out what that gap looks like?
I would actually disagree, because there is that statute in the health code, which admittedly we don't have a private right of action to enforce, but we do have a private right of action under the common law, which incorporates the statutes. And that statute in the health code says any property, any place owned or operated by a governmental agency that is not maintained in a sanitary condition is a public nuisance, dangerous to the public health. And so we think it does incorporate that question, the same causation principles as the restatement.
Well, and I appreciate that, but do I understand your argument correctly that with respect to what I will call generically causation, or, connection between a public nuisance and how to remedy that, your argument is that although public nuisance is statutory, we should look to the common law for remedies?
I think that's correct. I mean, there are statutes that allow courts to abate nuisances and things like that, and allows the Attorney General or the Health Department to abate nuisances. But we as private plaintiffs have never maintained that we have a right of action under the statutes, but that's irrelevant. We have a right of action under the common law. That's the same common law that Armory Park's neighborhood relied upon. And as long as we show that special injury, which I don't think they're denying, because if we have a private nuisance, which I think we've shown, and they're not really disputing, then that gives you standing on behalf of the public also to assert a public nuisance, which then incorporates, I think, the state statute. But let me say a bit about the causation point, because I think this is very important. There are two ways. Well, three, depending on how you count here. There are really two ways to show causation. One is active steps to contribute to the nuisance. The judge found this through courtesy rides, through the fact that there's the zone pre-2018 and there's the zone after 2018. HSC, CAS, they'd been there for decades, and yet no one thought that there was a need, right? So there was a change, and that change was the city's decision to operate this shelter. And then there's the maintenance.
I know you have another point,
Please.
but before you get there, Ben, I said I'd be quiet, and I'm letting you down.
This makes it easier for me. Thank you.
You mentioned the courtesy rides. Where in the record do we know how many of those were given, and how many of those people who were given there to, I think, get services, stayed in the zone? Because wouldn't you need to kind of look at both of those?
Perhaps, but it is a preponderance of the evidence standard, right? And the question is whether the judge's trial findings here were clearly erroneous under that standard. And what the testimony at trial showed was that not only police officers would give courtesy rides, there's actually a procedural order where it shows that they give courtesy rides to that area for people who need services. The testimony also showed that the city funds and coordinates with community bridges who transport lots of people down there. And then the judge basically made a finding that and then they let the people there, they don't follow up, they don't see if they actually get services, and what are they going to do, when they get there and it's like, oh, look, it's a big tent city, right? Obviously they understand that there is an amenity here.
Well, and there are a couple of things with that. Let me just, so I'm clear on that, do we know numbers?
We don't, Your Honor.
Okay. And then the other thing, is it a police function to transport homeless people back after they receive services to where they were found, given they're homeless?
I believe I think what the trial testimony showed was that they were dropped off and then the police ended their role.
And I read it the same way. It's just, I'm not sure they're in the business of providing transportation as opposed to enforcing the law.
I don't disagree with that, but of course, if there's an unsheltered individual violating some other ordinance elsewhere in the city, they have two options. You can cite them, which they don't want to do, or you can send them to the zone where everyone else hangs out. And that's what they did, and the judge found that testimony persuasive. But to be clear, we don't think we have to rely on active steps. And that's because the second prong of causation is landowner liability. The brief statement provides in Section 838 that a landowner is liable for the nuisance-creating activities of third parties if either it consents to the activity or it fails to take reasonable steps to abate the activity. And here, we think it is indisputable that they consent. We cite the parts of the record here on answering brief, page 30. There is testimony from Scott Hall, from everybody in the Office of Homeless Solutions. They were asked, Okay, so you offered this person a shelter. Okay, so this person had housing. I think one person had permanent supportive housing. What did you do if they didn't want to go back to it or they wanted to stay there? They said, oh, it's all voluntary. I can't force anybody to go anywhere. If that's not consent, I don't know what consent means. They're literally saying, oh yeah, it's a choice. Yes, we have this space available for you elsewhere, but if you don't want to take it, you can stay here. If that's not consent, I don't know what is. And even assuming that they didn't consent somehow, the next step then is reasonable steps to abate the nuisance. And the proof, again, is in the pudding. I suppose that's an expression. When the injunction was actually issued, it turns out that now 80% of them said, oh, we don't have a choice now? I guess I will accept that non-congregate shelter you're offering me, that hotel room or that congregate shelter or that alternative space, or we'll just leave and go somewhere else. I don't know, but I guess 20% of them must have done that. But what's also very interesting is that the city does some math, or we can do some math based on the city's numbers on page 11 of its brief. According to page 11 of its brief, there were over 110 beds available and unoccupied before the preliminary injunction was issued, let alone the permanent injunction. They had 100+ beds available. Why weren't they using them? Because it was voluntary. And because it was voluntary, they consented to the activity and failed to take reasonable steps to abate it. So just to be clear, Your Honor, we absolutely support the Superior Court's finding on active steps. We don't think they're clearly erroneous, which is the standard here. But we, the judge, as I think Judge Brown mentioned earlier, did say maintaining the nuisance. I wish the Superior Court had unpacked that a little bit more in its order. That's what I was trying to do here just now. So if I may, Your Honor, since I have a little bit more time, I know I want to get to judicial role. They did cite a case in their reply brief that I want to address because it was in the reply brief. It's a Ninth Circuit case called Team Enterprises. They cited it for the proposition, quote, owning property is insufficient to establish causation for a nuisance created by a third party, which if true, would be bad for us. I mean, it would contradict all the other cases, but that's not what the case says. The case says owning property is not a necessary condition, which is totally different, right? And we don't dispute that. It cites a case, City of Modesto, 119 Cal App 4th 28, which said it has long been the law in California that not only is the party who maintains the nuisance liable, but also the party or parties who create or assist in its creation. So even in California, Your Honors, one who maintains the nuisance is just as liable as those who create it. That helps our position. It's the same law in Arizona, and that's why we think we win this case. I'd like to wrap up, unless there are, of course, questions on causation, which I know is a central issue, with just a couple points about the judicial role. Again, in their, less so today here at oral argument, but in their briefing, right, they make it out as though we are trying to make this court to be a policy star. So let me go back to something I said at the beginning. We are here because the people of the state enacted through their representatives state statutes involving public nuisance. Of course, there's also the common law of nuisance. So we, the people, have made this policy. There's also city code, which Ms. Duhan mentioned. We inexplicably omitted it in our briefing, and so let me give you the citations. I think she did as well. Code 23-30. 23-48.01, those are the camping and sleeping bans. And then, of course, there's 31-9B, which makes it unlawful for any person to encroach on the public rights-of-way, which they used against our plaintiffs when they tried to put sculptures up on the rights-of-way. They said, no, you're encroaching. So the point here is we, the people, through our representatives, have already made the policy, and we are asking this court to enforce that policy. There's also the point about the Ninth Circuit, which we heard a lot more about today at oral argument than we did throughout the lower court proceedings, if I might add. I think this is another reason this court has to issue a ruling here on the merits. They are confused about the Ninth Circuit law. We explain that in our briefing. What are courts, and we, the site, I don't have the exact page where we talk about it. I do, answering brief 29, where it goes through the record citations where they say, yeah, we're confused. We don't think we're allowed to do the thing the plaintiffs are asking us to do. What are courts for, if not to correct erroneous misinterpretations of the law in a real case of controversy with adverse parties, which is what we have here. So again, we're not asking you to be policy stars. We're asking you to interpret law, a Ninth Circuit decision in this case that
you're not asking us to overrule the Ninth Circuit, right? Which we lack.
The Supreme Court will do that shortly, Your Honor.
The Supreme Court will do what it chooses to, but as I understand that case, certainly the Ninth Circuit is not binding on this court. Would you agree?
That's correct. This court and the lower court can make their own interpretations of federal law, and the only federal court that has a right to review it is the United States Supreme Court by virtue of Section 25 of the Judiciary Act of
And that
1789
assumes-
for the students in that audience.
That assumes that we need to interpret and construe federal law.
Correct.
And much of what we're talking about here is state statutory or common law.
Absolutely, absolutely correct. We don't think the Ninth Circuit decision, so that's all true. But if this court were to take the city at its word, that they feel bound by the Ninth Circuit and the court felt a need to address that, we are not challenging the Ninth Circuit decision. We think it's wrong for a number of reasons, but we're not challenging it because we don't think the relief we want violates it. They think it violates it. We don't think it does. That's a legal interpretation question where courts are here to resolve if necessary. Of course, Your Honor, they also mentioned immunity and political questions. So let me say two quick things about that, and then I think I will close. I think the court received our Rule 17 letter. I don't think the other side, maybe they will on rebuttal, but I don't think they disagree that immunity seems foreclosed by Ziegler and the Cromco cases because we're seeking injunctive relief. And that makes sense. Immunity applies to damages, against government officers, but they don't get immunity to keep violating the law. That's not what immunity doctrine is for. It's a claim against money damages. That's also the federal law. So again, that's what courts are here to enjoin, ongoing violations of the law. As for the political question doctrine, I don't think that is a serious argument for the following reason. That usually requires a lack of a judicially manageable standard, but we're dealing with cognizable, longstanding common law claims and state statutes. So how is this not a cognizable standard, a judicially manageable standard? Nor is it the kind of thing that requires unquestioning adherence to the determinations of the political branches. So the two famous federal political question cases are, what's the legitimate government of Rhode Island, during a rebellion, the Doors Rebellion? And, what is a valid impeachment and so on? It's nothing like this case. So let me close, Your Honor, just with the following observation. I think the issues in this case go to the heart of the social compact. That may seem like an exaggeration, but I think they go to the question of whether we are entitled to live in a well-regulated and well-ordered society. And I think this court's decision here has the potential to reverberate for many decades. Thank you.
Thank you, counsel. Ms. Doohan, rebuttal.
Thank you, Your Honor. Two key points. This case is not Armory Park, and it's not Johnson. First, Armory Park, where a charity was offering a free meal a day to the homeless. The city does not own or operate the Human Services campus. The city, there's not a shred of evidence the city passed out tents to people to camp outside the Human Services campus. There's no evidence of the city telling people to go there to camp. There was evidence of occasional courtesy rides, and plaintiffs are correct that there were some law enforcement activities to drop people off if they were seeking service. But there is no evidence of the volume, the frequency, and in fact, Commander Freudenfeld testified at length below that officers would do a warm handoff where they walk people into the campus, they connect them with the service provider. No, they did not stay outside for the next hour or two and confirm where they ended up. But this isn't Armory Park. It's not just enjoining giving a meal. If this was Armory Park, the relief could be enjoin the city of Phoenix from doing courtesy rides to the Human Services campus downtown. But that's not what happened. At the heart of this case is about law enforcement. How many citations and arrests were made to people camping outside on public property during a time where there were, throughout the record, showing that there weren't enough beds to accommodate the number of homeless. It's similarly not Johnson. Johnson, the city of Phoenix, long time ago, old case, but the city was operating a sewer plant, and it was doing it in a way that created noxious gases and discharge into the Salt River. The city owned and operated that facility, and no matter how great the cost, the city was required to abate that nuisance. However, in this case, and I think you hear a lot of this from the plaintiffs, there's this idea that the city consented to people going down there, that the city ran an open-air outdoor shelter. That is not clear in the record below at all. In fact, the city has vehemently disputed that. The campus downtown didn't have enough beds, and there were people who were camping outside. So the city provided cleaning, tri-weekly. It started doing sanitation. Jeremy Huntoon at the permanent injunction testified about making contact to see, can you be reconnected with family? Where do you need to go? What type of services? Is it a family? Is it a working adults? The city worked to place people in shelter. It didn't maintain or consent to that area being a homeless encampment. I see you questioning for a minute.
I'm just wondering, okay, hypothetically, the city has many parks.
Yes.
Hundreds, if not thousands. a homeless population moves into the city park. The city has done nothing wrong, didn't invite it, didn't cause it, didn't maintain it. But yet, if I'm a neighboring property owner, I'm pretty upset that this has happened. What are my options? Can I not sue the city for abatement of the nuisance if the city doesn't take reasonable steps in a meaningful period of time to abate the nuisance? In other words, it's not I can't do anything about it as a adjacent property owner. Only the city can deal with it. So there's no causation, there's no maintenance. And yet, in my mind, the city has an obligation to do something about that nuisance.
Your Honor, I think there's two answers. And the first would be, if you look at sensing, there's always remedies in terms of going to your city council, going to your leaders, asking for more enforcement, asking for more resources, taxpayer dollars committed to housing the homeless. There is a political answer.
And I understand that, but if I change the facts just a little bit and say it was my private, I own a lot, and people have moved in on my lot, again, I as a property owner, I'm going to get a notice probably from the city of Phoenix saying, you need to clean that up. Nobody allowed you to start running a homeless shelter on your lot. You need to clean that up, Mr. Brown. So it's a difficult situation. It's and I understand that the things that we're talking about are very challenging, but it seems like the city has the same obligations as a private landowner in this situation.
Your Honor, I agree that the city has the same obligations in terms of a private landowner of maintaining its property in a condition free of nuisances. However, it doesn't have the same legal abilities. When you look at the nuisance case law, throughout the recitement, you talk about reasonableness. Did you take, even if you extend nuisance law here, did you take reasonable steps to abate in Section 839? Section 838, did you exercise reasonable care? It's important that this court realize when you're dealing with a public entity like the city of Phoenix, reasonables can mean law enforcement. Where Plaintiff Brown can have somebody simply trespassed, the city of Phoenix is going to have limitations based on ability to provide shelter and taxpayer resources. Rural Arizona, cities and towns with very small budgets could struggle. And the question is, as we end, does this court want lower courts, the judiciary, second guessing every reasonableness determination while cities try to respond to issues like homelessness? Thank you, Your Honor.
Counsel, thank you for your presentations today. Thank you for your briefing. You've given us much to think about. We will take the matter under advisement and we'll issue a written ruling in due course. Court's adjourned.